Bale.
A very good afternoon to all. We have in our In Conversation series an eminent lawyer who was born in a Belpu village of Udupi, and from there to the corridors of Supreme Court, he has a glorious career and is serving the judiciary for now more than 60 years and has also appeared in several important cases. He is none other than Senior Advocate B.V. Acharya, and it's our honor and privilege to have you, sir, on our portal. Where we'll be talking about his wonderful journey, and we'll be knowing his opinion on various subjects. A very warm welcome on Verdictum, sir.
Thank you.
So I'll directly start with the questions.
Yeah.
First question is, sir, in a span of more than 60 years, you have practiced at all courts and at all levels in the country, and you have seen the evolution in the legal system. So how you will describe it in your own words?
You see, so far as the legal system in our country is concerned, I do not find much of a change then and now. The hierarchy of courts and the method of the justice delivery system, all these have remained almost the same. And recently, because of the advanced technology which the judiciary has adopted, there have been changes in the administrative setup in the country. Now, that is, for instance, in olden times, getting a certified copy of the order was so difficult, it took a long time. But now, with computer and internet facility, you are getting the copies immediately. Even judgment copies are got because they are uploaded soon after they are pronounced. These are some of the developments on the administrative side. And more than that, because of the COVID pandemic, the big change which has come about is about virtual hearing. Today, since the last 2.5 years, I have not been physically attending the court because in our High Court, this hybrid procedure is even now in vogue. So we are entitled to address the court by sitting in your chambers and arguing the matter. This is a major change which has come about. A lot of journey and time is saved because of this. Similarly, this video conference facility has helped the criminal courts. See, getting prisoners from the jail to the court premises for getting their remand, which has to be in their presence, is a very big task. Now the police don't have that burden because the magistrate can order continuation of the remand by use of the video conference facility. These are some of the major changes. For once, the entire bar has become united. Any lawyer from any part of the country can address the court, either Supreme Court or any High Court, which was not possible. And if I am not mistaken, in some cases, even lawyers from London are addressing the Supreme Court. This is a radical change and a welcome change which benefits everybody. But for these changes, things are same. But one significant change is the volume of work. Dependency in the courts have increased so enormously that the justice delivery system is seriously affected. Only yesterday, the law minister made a statement in the parliament. The total number of cases pending before the Supreme Court as on today is 71,000, which never used to be more than 2,000-3,000 years back. When the Supreme Court started, there were only 6 judges. Today, we have 35 judges. With all that, the dependency has increased enormously. In all the high courts together, there are in our high court alone, Karnataka, more than 3 lakhs cases are pending. According to the law minister, in all the 24 high courts together, 59 lakhs and 59 lakhs cases are pending. And the total backlog in the entire country is 4.13 crore. This very pendency is affecting administration of justice. And today's newspaper has reported Justice Kaul of the Supreme Court said that if this is the rate of pendency and our disposal, it will take hundreds of years to clear the backlog, which is a very unfortunate situation. But for this change, of course, population has also increased. Correspondingly, litigation has also increased. But for these changes, I do not find any change in the system.
Moving on to the next question, sir.
Please.
So you have visited different countries as a delegate at several conferences and have studied their legal system. So how will you analyze our Indian legal system in comparison to theirs?
You see, in my humble opinion, our system is much better than systems in many countries. And at any rate, it is not worse than any other country in the world. Now we have adopted Anglo-Saxon system of administration of justice. We have adopted adversarial system. In some countries like France, etc., it is inquisitorial. That is, in those countries, in respect of criminal cases, even the judiciary and the prosecuting agency also takes part in the investigation. This is not a healthy thing. So far as we are concerned, judiciary is absolutely independent, prosecuting agency is again independent, and investigating agency is separate. This system, according to me, is good. And therefore, compared with any system, except for the pendency for which we are responsible, our system is quite all right. Some people say it is a colonial legacy and you should adopt Indian system of administration of justice. I do not find any need for such a change.
So the study of law has seen a drastic evolution in the past decade. And the study of law then and now has seen a paradigm shift. So how do you see it and what changes according to you are required?
You are right in saying that there has been a lot of changes in the method of study of the legal subjects. Now, when I was a law student, except the lecturer coming and giving lectures to about 200 students in one class and going away, there was no interaction between the students and the teacher. There was no other method of study. There was no moot court competition, no group discussion, nothing, no practical training. Only few important subjects, that too conventional subjects, jurisprudence, contract, Hindu law, etc., were taught. And there was no further. Now, today, situation has totally changed. Thanks to the establishment of National Law School of India University in Bangalore, we have all worked very hard for the start of that university. In fact, late Sri Ram Jethmalani was the main person when he was the chairman of the Bar Council of India. He wanted this to be done, and the school started. As you know, after that, the situation in the country has changed. Today, there are as many as 17 or 18 national law schools all over the country, and the method of teaching has changed. In fact, Dr. Madhav Menon is the person who has brought about many changes. He was the first director of the school at Bangalore. Later on, he went to West Bengal. So today, the method of teaching has changed for the good. I do not consider myself competent to say much about the reform in the system, but I can say only one thing. Brilliant students who come out of these prestigious institutions do not wish to join the profession or become judges. On the other hand, most of them get themselves included at the campus selection. This is not a healthy practice. According to me, those who can afford and brilliant students should join the profession, which will enable improving the standard both of the bar and bench.
Absolutely, sir. So moving on to the much discussed topic in our country, what is your opinion on judicial activism and how do you perceive it to be?
See, judicial activism has not been clearly defined anywhere. Different people have different idea of judicial activism. According to me, there are two ways of looking at it. If by judicial activism you mean the judges become active and progressive in their outlook, in their interpretation of the constitutional provision or other laws, so as to fulfill the needs of the present day society, such a progressive outlook and progressive method of interpretation is welcome. And that type of judicial activism we welcome. Now, I will give only 2 or 3 instances. The expression of Article 21, right to life. The old idea was it is just physical existence. Now, our courts, particularly Supreme Court, gave new life to the definition of life. Right to life includes right to live with dignity, right to pollution-free environment, right to shelter, health care, nutritious food, reputation, right to livelihood by means which are not illegal, and every aspect of life which will go to make a man's life meaning and worth living. This is judicial activism. Similarly, in Keshavananda Bharati case, the word amend, the definition that amend means you can make any change. The Supreme Court curtailed that right with the theory of basic structure doctrine. That is judicial activism. Similarly, Article 14, which only dealt with want of discrimination. Now, a new dimension is given, and they said any action which is not, or any law which is not just fair and reasonable will be manifestly arbitrary. Any manifestly arbitrary action can be nullified by the order of the court. Now, these are the areas of judicial activism. But some others interpret judicial activism as saying the executive and the legislature are not performing their duties properly. Therefore, we give directions virtually encroaching upon the field of the executive and legislature. That is not judicial activism. According to me, that will amount to judicial overreach. Now, judiciary has the responsibility to see that every organ acts within its power. Now, if the judiciary itself transgresses its limit and trespasses into the field of executive or legislature, there is no remedy. As you know, if there is legislative or executive access, you can immediately approach the court. It can strike down that action. It can even stay it. Even a legislation can be struck down or stayed. But if the Supreme Court itself goes into the field of executive, then we have no remedy. Now that will be judicial overreach, which should not be encouraged. That is my views so far as judicial activism is concerned. It should not become judicial overreach or even judicial tyranny, as some people put it.
Moving on to the next question, which is somewhat connected to this issue.
Yeah.
We have seen that several important issues of public welfare has been addressed with the help of public interest litigation. So what are your views on its relevance?
You are right. The earlier view was it is only aggrieved party who can go to court. But for the first time, that theory of locus standi was relaxed, and any public spirited person can come and seek relief in favor of those who, either because of ignorance, illiteracy, want of knowledge, poverty, etc., are unable to approach the court. A public spirited person can approach and get them relief. For instance, bonded laborers, prisoners, children, women, other weaker sections of the society, Adivasis, etc. That was good, and that did happen. The courts entertained PIL and granted relief to many people. But in course of time, this became virtually a sort of business with some people. Some people have taken it as a profession, PIL. Even it is not for the benefit of any particular section of the people, but just say it is in public interest and PILs. Now it became such a thing that the Supreme Court itself had to say that this has become a virtually the wording used is that it has become a nuisance. In fact, I will quote from one judgment of the Supreme Court as early as in 2008. Thus, public interest litigation, which was initially created as a useful judicial tool to help the poor and weaker sections of the society who could not afford to come to courts, has in course of time largely developed into a uncontrollable Frankenstein and a nuisance, this is the word used, which is threatening to choke the dockets of superior courts. Now today, the situation is much worse. In fact, most of the judges and many lawyers agree that at least more than 90% of the PILs are really not in public interest. They are all for private interest. In fact, as early as in 1987 itself, in the case of Sachidananda Pandey, the Supreme Court itself, Justice Khalid, in a separate judgment, wrote that if we don't control this, it will affect the genuine litigation. Today, after 35 years, it has come true. According to me, frivolous PILs, time spent by the courts on them is so much that the genuine litigants who have waiting for years and years together get justice are not able to get justice. On the other hand, so-called PILs get precedence. They get top priority and time is spent on them. This is a very unhealthy practice. Therefore, some may say it is a very radical point of view. I would even suggest a moratorium on PILs at least for some time, or otherwise, no doubt courts say we should be very careful and selective. At least if a total ban is not feasible, according to me, there should not be oral hearing in the matter of PILs. The PIL could be filed and a committee of judges should decide which PIL deserves to be entertained. As they do in Supreme Court of America, nobody has a right to file a case. He files and judges pick out the particular number of cases per year. Like that, the PIL, the judges can take and then even suo motu action they can do. Otherwise, it will be many cases are only for publicity. Last week, there were 8 PILs on one subject, and one of them raised an objection that it should be placed number 1 because tomorrow in the law reports you will get that name, that X is the person in whose name this PIL was allowed. This is merely publicity. Therefore, as they have been saying, today it has ceased to be, P doesn't stand for public interest. It stands for political, personal, private, pecuniary, and all such interests and publicity. Therefore, I feel that there should be some restriction on this PIL in future so that the genuine litigation will get precedence.
So in the beginning, sir, you spoke about the pendency of cases. So for reducing the pendency of cases in India, what solution do you propose?
Of course, the problem has reached such a gigantic proportion, it is very difficult to say what are all the reasons. But most important is recruitment of sufficient number of competent judges. Today, the judge strength is not commensurate with the number of litigations or the population. So, judge strength must increase. And appointment of competent judges. By competent, I don't mean academically highly qualified. That will not help. The qualifications required for a judge is different from the qualifications required for a lawyer. A judge must have the capacity to judge quickly without wavering. Now, we have seen even among judges, the total number of cases disposed of by one differs from the other. Therefore, we must have judges who are able to quickly dispose of cases. And as you know, I have always been advocating, though we are adopting British system, somehow we have not adopted the practice of writing short judgments. Every case, particularly where it is a matter where 3 or 5 judges here, you write hundreds of pages or thousands of pages, and some are even concurring judgments. That is not needed. These are all the important reforms which we can think of for bringing down the pendency. Another is so many frivolous criminal cases are filed, and the High Court's power to quash such frivolous cases is curtailed by the Supreme Court. Supreme Court must have more confidence in the High Court judges, and they should not curtail the power of the High Court to nip it in the bud wherever there is a frivolous litigation. It should be stopped stopped at that level. These are some of the suggestions which I make for improving the system and bringing down the dependency.
So my next question is, sir, what are your views on the current mechanism for the selection of judges? That is the collegium system. And according to you, do we need some changes into it or not?
See, my sincere opinion is, as you know, till 1993, second judge's case, till that case, it was the executive which had the upper hand. CJI and Supreme Court judges were only consulted, not concurrence. For the first time, as you know, in the second judge's case, the Supreme Court said CJI's consultation means concurrence. And a new idea which is not found in the Constitution was developed. That is the collegium system. By this judgment, the power of the executive is totally taken over by the collegium of the Supreme Court. In fact, many authors and jurists have said, by way of interpretation, the Supreme Court has virtually rewritten the Constitution so far as appointment of judges to the higher judiciary is concerned. Now, all round, there was a demand for constitution of National Judicial Commission for appointment of judges. And such a proposal ultimately culminated in NJAC Act and the 99th Constitution Amendment with regard to the appointment of judges. And these two twin legislations, as you know, were passed by the Lok Sabha and Rajya Sabha unanimously, with the sole dissent in Rajya Sabha. But yet, the Supreme Court Constitution bench, with the Justice Chalameshwar dissenting, struck down both the Constitution Amendment and this NJAC Act by saying that this will impede or interfere with their independence of the judiciary. This is an unfortunate development, and this enabled collegium system to continue. According to me, NJAC Act was the best solution to the problem. You see, there judiciary is well represented. 6 people in the commission, of them 3 Chief Justice of India and 2 senior most judges, 50% there, and 1 is Law Minister, and 2 eminent people to be selected by no less a person than CJI, Prime Minister, and leader of the opposition. Now, the Supreme Court found fault with this also. If you don't even trust a committee of Chief Justice, Prime Minister, and leader of the opposition to select 2 eminent people, whom else can we trust? According to me, NJAC is the solution to the problem. I feel at any future date, the Supreme Court itself should reconsider the decision, and the dissenting judgment of Chalameshwar should become the law of the land. This, according to me, I have been saying this all through, and there are so many eminent jurists, including Sri Mukul Rohitgi, the former Attorney General. He has also advocated this and that, in public requested the Supreme Court to consider its own wrong and graciously reverse this decision. This, according to me, will be a solution for the problem of filling of vacancies in the High Courts and Supreme Court. Even other day, though there are so many vacancies, the collegium is not able to arrive at a solution. They simply postpone the matter. And though at one stage, the decision of the collegium was proposed to be published that very day, later on, even that practice has been virtually given up. With the result, it is considered to be a very secret decision taken, want of transparency in the method of selection. This is my view in the matter.
So now moving on to your professional career. So you have appeared in various important cases, for example, the disproportionate asset case against Jayalalitha and many more. So can you tell us about your experience while handling such important cases and which case has been a turning point in your professional life?
You see, for a lawyer handling a case, every case is important. He has to devote his full attention and do justice to the case. According to me, every lawyer, after should evaluate his performance at the end of the case. Result is immaterial. It depends on so many things. A lawyer must see, have I done my best for my client in the case? If the answer is yes, he will be satisfied. In the case of Jayalalitha or any other high-profile cases, one problem is the parties are powerful, not only in the matter of money and power, but also area of influence. There will be a lot of pressure on the advocate. That is why Supreme Court directed, while transferring the case, that a senior advocate selected by the Chief Justice of the High Court should be appointed as public prosecutor. That is why I was appointed. The public prosecutor appointed in such a case should be free from all pressures and should be able to withstand pressure, whether it be from any side or whatever. Barring that, there is no other difficulty. And so far as the turning point in my life is concerned, as you know, I have practiced in Bangalore for 16 years, up to 72. And then, at the request of my friend, I shifted to Bangalore. I never thought of that because my entire ambition was to be a successful lawyer in Bangalore. But then events were such that I came to Bangalore, which gave me the opportunity to serve at the state level. And the important turning point case is the tape case of Sri Veerappa. There was Justice Desai Commission with regard to the allegation against the then leader of the opposition, Sri Veerappa, and I appeared for him. I was opposed by Sri R.N. Narasimhamurthy, who was earlier Advocate General and a stalwart in the profession. I was not much known in the field, and I won that case, and that case has received wide publicity in the state for a long time. That was a turning point in my life, and most unexpectedly, within 2 years of that case, I was designated as a senior advocate by the High Court, and the same year, the state government appointed me as the Advocate General with Sri Veerappa himself as the law minister. And 2 years later, Veerappa himself became the law minister, and I was again appointed as Advocate General. Thereafter, of course, 3 more times. In all, 5 times I assumed office as the Advocate General. Apart from all other things, the luck of a person also plays a dominant role in his career. But when the luck is in your favor, you should do justice by working hard, sincerely, and honestly.
Very well said, sir. So what are those necessary skills of litigation that every lawyer must possess to become a successful lawyer?
You see, according to me, first and the foremost is hard work. A lawyer who says, I have been successful without doing hard work you will not be telling the truth. Unless you work hard, you can't succeed. Then there are few qualities which you can develop by experience. One is the power of expression. After all, your job is to convince the judge. In olden times, when there was jury system, even oratory counted, but not now. When the judge is there or judges are there, you must have good power of expression. And for that, you must have good vocabulary. These are things which you must have. You must have good language and capacity to use proper expression and what they call communication skill. These things will have to be developed. And beyond that, one most important thing is you must follow very strictly professional ethics. You must earn the name that here is a lawyer who is strictly following ethics. And then another tip I can give is general knowledge of any subject, need not be law alone. Any subject, general law, will one day or other come to your help in discharging your functions. And fourthly, a lawyer should never bother about the quantity of work, but he must concentrate on quality of the work. This is very important. If you adopt all these qualities, even though you feel that you are an average person without much of a so-called intelligence or academic qualifications of doctorate or anything, that may not help you. But these qualities will help a lawyer to come up in the profession. That is my experience and my views.
So finally, sir, what is the message towards our young lawyers and law students, how they can serve their duties with the best of their abilities?
I think answer to this question lies in my answer to the previous question. I have stated all those are relevant for this also. And one message to young law students, as I have already said, after completing your studies, if you can afford it, by that I mean you are not hard pressed for immediate job, you are unable to sustain yourself. If such a situation is there, if you can wait for 3 or 4 years, enter the profession. Don't go and join some firm because as a law officer or in another capacity, a company pays you regular salary. Don't be tempted by that. Instead of that, if you are really capable, please join the profession. And once you are a lawyer and a successful lawyer, you can either succeed as a lawyer or succeed as a judge, even become a judge of the Supreme Court of India or the Chief Justice of India or the Attorney General of India. All these avenues are open. So my advice is join the profession. I wish them all the best.
Thank you so much, sir. Thank you so much, sir, for your kind words and coming to Verdictum. We will be looking for more insights for you in future.
Thank you. Work, please. Nice.
Thank you.
Thank you.